Welcome. We are visiting the values of the judicial system. We are in 2020. Let us go back to 1940, 1945, that era when Sir Shadi was a member of the Privy Council. He had written one judgment which is declared as the model judgment. This judgment was admired and agreed by the Chancellor of Privy Council as well. Lord Chancellor Privy Council had written on it, I admire and agree. Now, this judgment is titled Atmaram Abhimanji versus Balaji Rao Janrao. It is cited as 139 AIR. This judgment is just a judgment of 4 pages, and this judgment as it is be approached by us, visited by us, absorbed by us, taking it to be that if we want to learn the art and science of writing a judgment, art and science of drafting, art and science of interpretation, art and science of making language as a tool of expression. So we as students of law, we as lawyers, we have to learn language, how to reach at the meanings, how to interpret the technical terms and technical paragraphs and technical statutes, technical provisions, and then how we have to be specific, express, then choice of our words, the composition of our sentences, the paragraphing, and the theme to be reached from the first sentence to the last sentence of the expression as an essay, as a judgment. These all values are to be learned by us. We have to start from the very beginning. The very beginning will be that we should start with ABC of the language. Our words should be simple, which are non-ambiguous. Our sentences should be short. These should be grammatically correct. These shall have a smooth flow of the thought and meanings for which these words have been chosen, for which these sentences are being composed, and the paragraph to be made and complete essay, complete judgment ultimately shall give a clear-cut flow for the decision for which this judgment is being written. This judgment is about the Hindu law. It is about the concept of sambodhika. This concept is ancient concept. It is a classical concept, and the litigation with respect to it during that time, now the Hindu law has been much amended, but during those decades, it was a very prevalent concept, and it was of the core of many litigations. This judgment is a second judgment from India to England, where was the seat of Privy Council. The trial court had accepted the original suit. The first appellate court had reversed it, and then it was a second appeal, final appeal before the Privy Council. The appellants have not joined those proceedings. Everything was left to the wisdom of the court, and the Privy Council, in terms of the judgment and reference, reversed the first appeal court, and the judgment of the trial court was restored. Now, all this what I am saying is just to impress upon as that the judgment is to be reached at by the judge. Parties only have to assist. Even if there is less assistance, even then the court will reach at the conclusion. Now, the subject matter of this litigation has been the relationship of Sambodhka and its lawful effect upon the legal inheritance. The law was of classical domain. Sir Shadi Lal was a student of Sanskrit, mathematics, English, and law. So we can say that he was a child having growth in the village area, in the rural area of Haryana, and he was a student of Sanskrit, mathematics, and law. And the subject matter here also was of that very domain of classical Hindu law. Some texts were to be interpreted, and in these 4 pages, he has successfully reached that full expression for the classical concept of Sambodhka. Let me read its judgment. It starts like this: the question of law which arises in this appeal is one of considerable importance, and relates to the exact scope of expression of Sambodhka as used in Hindu law of inheritance. Now see, in the first sentence itself, everything has been specifically expressed as that what is going to be adjudicated here, what is going to be determined here. So the question of law which arises in this appeal is one of considerable importance and relates to the exact scope of expression of Sambodhka as used in Hindu law of inheritance. So this composition of this sentence as the first sentence educates us that while we are drafting, or while we are writing an essay, or while we are expressing upon a particular theme, how much explicit we shall be. We shall be very clear at the outset, in the beginning itself, as to what precisely we are going to chase. The second sentence says, the facts bearing upon the question do not admit of any dispute. See the second sentence. In this sentence, it is made clear that facts are not in dispute. Means the facts which have come on record, the case file facts are clear, these are admitted, there is no dispute with respect to the facts. So by this sentence, it is made clear that only point for determination is the legal domain, as it is made clear at the outset in first sentence. So the first sentence says that there is a question of law, and what that question of law is, this as to the scope of expression Sambodhka as used in Hindu law of inheritance. So these 2 sentences make it much specific, the journey which is going to be there in this judgment. The facts are not in dispute. and the question of law as well stands determined and specified. Now, the third sentence is the property which is in dispute between the parties belong to Manik Rao, who died in October 1916. Now, see, the facts which are not in dispute are being made specific, and it takes us to the property, the original, the owner, and the date of death of the owner. The property which is in dispute between the parties belong to Manik Rao, who died in October 1916. The plaintiffs are descended in the male line upon one Tul Singh, who was an ancestor of Manik Rao in 22nd degree. See what is being now focused here. The Tul Singh is the person who is ancestor of Manik Rao, and the degree is 22nd. So if we draw the pedigree table from Tul Singh to Manik Rao, then it is going to be 22nd degree. Now, this sentence further specifies as that the property with respect to which inheritance is going to be determined in the context of Sambodha relationship is that here the 22nd degree is the fixation flag point. So when we will proceed further, we will imbibe the importance of this 22nd degree mention. So the factual position is that the lineage is of 22nd degree. We will come to the importance of this fact being mentioned at the outset only when ultimately we'll know that Sambodha relationship extends only up till 14th degree. So what is going to be determined ultimately, what is going to be settled in terms of this judgment is that the inheritance as per Sambodhika relationship is to extend only up till the 14th degree. However, here in this fourth sentence, it is made clear that factual position is as that plaintiffs are descended in male line from one Tul Singh, who was an ancestor of Manik Rao in 22nd degree. You see, the property was owned by Manik Rao, and the plaintiffs are related with Manik Rao from Tul Singh in 22nd degree. So ultimate determination is to be whether the Sambodhika relationship which plaintiffs are claiming with Manik Rao will extend up till 22nd degree or not. The interpretation that way is to determine whether the Sambodhika relationship for the claim to property extends up till 22nd degree or not. Now see the next sentence, sixth sentence. They claimed the estate on the ground that they were entitled to succeed to it as the agnates of the deceased in preference to the defendant Atmaram, who was his father's sister's son. The trial judge negated their claim, but on appeal his judgment was reversed by the Court of Judicial Commissioner, Central Province and Brar, who have held that the plaintiffs come within the purview of the term Sambodhika and have priority over the defendant, who being only a bandhu cannot succeed in presence of an agnate, howsoever remotely the latter may be related to the deceased. See, this sentence is a big sentence. It is a composite sentence. But see the justification of this sentence. This sentence is firstly continuing the original thought that the trial judge and the appeal judge. So, link is being shown who was the trial judge and what happened to the judgment of the trial judge in appeal. And the appeal court was the Court of Judicial Commissioner, Central Province and Block. And then the concept of the Sambodhika, as was accepted by the trial court, stands negated by the appeal court. Now, therefore, the terms comes to be agnate, bandhu, and sambodhika. There are three words now which are the catchwords, and these catchwords will become the subject matter of the further chase, further interpretation, further adjudication. Now see, the judgment really starts. The heirs of Hindu governed by Mitakshara school are Spindas, 20 failing them Sambodhikas, and in failure of both the above mentioned class Bandhu. See, the Hindu law of succession is being precisely summed up here. The heirs of a Hindu governed by Mitashkara school are Spindas, failing them Sambodhikas, and on the failure of both the Bandhus. So, original is of Spindas, then is of Sambodhikas, and then is of Bandhus. Now, here the dispute essentially remains between Sambodhikas and Bandhus. So, if Sambodhikas domain covers the plaintiffs, then naturally they will succeed. Otherwise, it will fall upon the Bandhus. The word Spinda includes blood relations to the 7th degree reckoned from and including the propitious, as it is obvious that plaintiffs who were related to the deceased Manik Rao in 22nd degree are not his Spindas. So, Spindas are descendants up to the 7th degree only. So, when the plaintiffs are at 22nd degree, so naturally they are not the Spindas. They, however, claim to be Sambodhikas, and that class certainly includes all the ignates from 8th to the 14th degree. Now, here, this sentence appears to be a pre-conclusive statement, because this statement, this sentence, they, however, claim to be Spindas, and that class certainly includes all the agnates from 8th to 14th degree. Now see, that class certainly includes all the ignates from the 8th to the 14th degree. It is a conclusion. The conclusion is being well expressed here itself, taking it to be that while Spindas are up till 7th degree and Sambodhikas are only up till 14th degree. But from where this statement has come, this will be followed when we will have a subsequent chase of this judgment. But it is a debatable question whether agnates beyond 14th degree come within the ambit of Sambodhikas for the purpose of succession. Now see, the above sentence in a way is a conclusion that it should be only 14th. And then it is put that it is a debatable question. No, it is being said that there are some arguments in favor of the extension of the Subodhka relationship beyond 14th degree. But it is said it is a debatable. That means the point for determination of this judgment is whether the relationship beyond 14th degree will be covered within the ambit of Sambodhkas or not. It is in this context we have to be careful, as that unless and until you are very clear in your mind as to what precisely is going to be the conclusion of a judgment, then in the absence of the same, this sentence cannot come in the middle at the place as it has come in this very judgment. Therefore, the lesson is that before we start, we initiate dictating a judgment, drafting, or writing an essay, we shall be absolutely clear in mind. The mental journey shall complete prior to the journey for its expression begins. One shall start writing, one shall start drafting a plaint or a plea, or one shall start writing an essay only after one has already completed the journey of visit to the values going to be the expression in the drafting, plea, or in essay, or specifically here when before we start writing a judgment. So writing a judgment is phase and stage where the mental journey already is complete. Once we are mentally determined as to what precisely is going to be the conclusion of the judgment, it is only thereafter that one should start writing a judgment. Now, the next question is, it is to be regretted that the plaintiffs who are respondents in the appeal have not appeared to sustain their claim, but their lordship had the advantage of hearing the point fully and fairly argued by Mr. Parekh, and have themselves considered all that could reasonably be urged in support of the view taken by the Court of Appeal in India. See how much is the responsibility of the court and how big is the burden on the conscience of the court, as that in the eventuality when one party is not coming forward to assist the court, then how deeply the facts and values are to be adjudged. And this sentence of this judgment reminds us of our moral and legal duty, and as to how one is to discharge the burden cast upon the conscience of the judge, conscience of the author, conscience of the writer. Therefore, each and every sentence up till this in itself is a one complete volume. This judgment is being taken as a model judgment only as here in each sentence there is a sum up of very big reservoir of values which each one of us is to imbibe. Now we are going to the next paragraph. Now the word Sambadka literally translated means persons connected by equal libations of water by Vijishneshwara, the author of the Mitakshara, abundant, the ancient doctrine basing the right of inheritance upon the right to offer general oblations and founded it upon perpetuity. See, this sentence is a very, very big paragraph in itself. It is, on the one hand, taking us through the values domain and the concept of Sambodhika, and on the other hand, it is also taking us through the different layers of different authors, of different schools of thoughts having their divergence. Now, it is a very big thing. Number one, we are taking up the concept Sambodhika itself. On the other hand, simultaneously, it is being chased how the authors, how different schools are contradicting themselves or overlapping themselves, superseding themselves, diverting from each other here in respect of this very concept. Then the next sentence, so actually the judgment begins from this sentence. The next sentence is, after detailing the hairs coming within the class of spindas, he asserts, means the author, in chapter 2, section 5, verse 6, the law relating to Sambodhkas in these terms. So here is a quotation, and the quotation is that if there be none such, the succession devolves on Sambodhkas, and they must be understood to reach to 7 degrees beyond spindas, or else as far as the limits of knowledge as to birth and name extend. Accordingly, Ved Manu says the relation of spindas comes within the 7th person, and that of Sambodhkas extends to the 14th degree, or as some affirm, it reaches as far as the memory of birth and name extends. This is signified by Gotra. Today I am stopping here. Let us read this judgment up till this stage. Let us imbibe the values emerged so far. Let us make ourselves conscious as that such judgment at the final stage has its own importance, its own implications, and so the parallel responsibility. And we have to be conscious about all these features. Thank you very much. In the next session, we shall be picking up the thread from this phase and stage of this judgment. Again, thank you very much.